Welcome, and thank you for joining IL's webinar today titled Civil Justice Reform, Learning from Arizona's Success. My name is Brittany Kaufman, and I'm a Senior Director at ILS, the Institute for the Advancement of the American Legal System. We're delighted to have such a great attendance at today's program, and I know you'll find this program very informative. First, to start, I want to go over a few of our basic webinar logistics. So participants will be on mute for the full program. There is a chat feature where you can ask questions of Jonna Perlinger, our program host today. If you have any logistical questions, you can chat her directly. In addition, we'll be using the same chat feature to gather questions during the course of the presentation. And we've reserved a few minutes at the end of the program to answer questions of our presenters. So please send any questions that you do have to me, Brittany Kaufman, via that chat, and I'll ask those at the end of the program. So thank you in advance for doing that. Finally, information regarding CLE and additional materials will be provided by me at the end of the program, so stay tuned. So with that, I want to provide a brief introduction and welcome to kick off our program today. Thank you all for attending. We have a wonderful mix of attendees from around the country, which is wonderful. And I also wanted to say thank you to our Law Firm Council and Business Leadership Network who are sponsoring this program today, and to all the members of those groups who are attending. For those of you who are new to ILS, we are a national independent research center dedicated to facilitating continuous improvement and advancing excellence in the American legal system. So what does that mean? For us, that means we're a think tank that goes one step further. We are practical and solution-oriented. Our specialty is the development and application of innovative solutions for the toughest problems facing our system. We are lucky to work with experts and groups around the country to achieve this mission, and we focus on a number of different areas in our work, which includes civil justice, family justice, the judiciary, legal education, and the legal profession. In our civil justice work, which is the area that I direct, we work with state and federal courts, and we work at the center of the V, bringing people together from all sides to work to make sure our system is one that is accessible, efficient, and accountable for everybody. So with that introduction, it's my pleasure to introduce our panelists today. First, we have Chief Justice Scott Bales of the Arizona Supreme Court. Chief Justice Bales joined the Arizona Supreme Court in 2005 and became Chief Justice on July 1st, 2014. He regularly teaches courses as an adjunct professor at the law school at Arizona State University and the University of Arizona. He is also a member of the ABA's Law School Accreditation Committee, the Executive Committee of the ABA's Appellate Judges Conference, and the Council of the American Law Institute. Before his appointment to the court, Chief Justice Bales practiced law in Arizona for nearly 20 years as both a private and public lawyer. From 2001 to 2005, he worked at Lewis Rocha, where his practice focused on appellate and complex litigation. He also served as Arizona's Solicitor General from 1999 to 2001, Deputy Assistant Attorney General for the U.S. Department of Justice's Office of Policy Development, a federal prosecutor in the U.S. Attorney's Office in Phoenix, and a special investigative counsel for the Justice Department's Inspector General. He also clerked for Justice Sandra Day O'Connor on the U.S. Supreme Court and Judge Joseph T. Sneed III on the Ninth Circuit Court of Appeals. After graduating from Michigan State University with degrees in history and economics, he received a master's degree in economics and his law degree from Harvard. Our next presenter is Don Bivens, a partner at Snell and Wilmer in Phoenix. Don Bivens recently chaired the Supreme Court of Arizona's Civil Justice Reform Committee, which brings him here to speak with us today. He handles complex litigation of all types and corporate investigations. Don leads internal investigations for corporations and special committees of corporate boards on a variety of issues. He also handles election law and government relations. In addition, Don is a recent chair of the ABA section of litigation, a past president of the Western States Bar Conference and the State Bar of Arizona, the Maricopa County Bar Association, and the Thurgood Marshall Inn of Court. Don received his JD from the University of Texas School of Law and his undergraduate degree from Yale University. So with those introductions, We have a wonderful group of panelists here today. I really appreciate their time on this call, and I'm going to turn it over to Chief Justice Bales.
Well, Brittany, thank you for the introduction, and we appreciate the opportunity to participate today. I'm going to begin by talking about the background to Arizona's Civil Justice Reform Committee, the commission that gave rise to the recommendations that led to our reforms. And I guess the starting point from my perspective is our adoption of a strategic agenda in 2014 when I became Chief Justice. Our chiefs serve a 5-year term, and we develop a new strategic agenda to coincide with that term each time there's a transition. In my agenda, I gave emphasis to issues related to promoting access to justice and to improving court processes. Arizona, like many states and like the federal rules of civil procedure, embraces in Rule 1 the goals of promoting the just, speedy, and inexpensive resolution of cases. And I was interested in how we might change our rules to better accomplish those goals. Another important factor is that in Arizona, we had a tradition of being somewhat innovative in terms of our civil procedures. One of my predecessors, Tom Zlackett, in 1992, approved rule changes mandating voluntary disclosure in civil cases, and those have proven to be very effective. Beyond the Zlackett rules, we've been making some efforts on things like court time standards, trying to promote e-filing, experimenting with a pilot project for commercial courts, but we wanted to do more. And I was also conscious that efforts were underway by various groups nationally to look at how to improve the handling of civil cases. For example, we were aware that ILES had been working on some efforts in this regard, and quickly gave attention to the 2015 report that was done in conjunction with the American College of Trial Lawyers, the report called Reforming Our Civil Justice System. Another background point was the fact that the federal rules were being reviewed, and that resulted in amendments in late 2015. A third significant development was the Conference of Chief Justices launched a civil justice initiative. And while that was getting started, we didn't want to wait until that work was completed to begin our own efforts. Finally, just in terms of the background to how we got to our Civil Justice Reform Commission, in 2016, a couple years into my strategic agenda, we completed the first comprehensive review and stylistic revision of the Arizona Rules of Civil Procedure in more than 50 years. And that, as you can imagine, was a pretty substantial undertaking. When I put that task force together, I told them not to get sidetracked with substantive changes. I was concerned that we make our rules as simple and as understandable as possible, but I recognized that if you gave a commission too broad of a charge, it could get bogged down. So I looked at this as sort of a two-step process. We had the restyling effort, and as that was being completed, we then began thinking about how we might look at more substantive changes to try to improve the handling of cases in our courts. So that was the backdrop to, in December of 2015, our setting up, pursuant to an administrative order, the Commission on Civil Justice Reform. We charged that commission with developing not only recommendations for rule changes, but also possibly pilot projects. And again, the focus was keying in on how can we reduce the time and cost for resolving civil cases. And we also narrowed the focus by aiming specifically at our superior courts. The superior courts in Arizona are our courts of general jurisdiction. The courts have civil divisions that are distinct from the divisions that handle family court cases, criminal cases, juvenile cases. And they're also separate from the level of limited jurisdiction courts that handle small dollar controversies of less than $10,000, and that also handle eviction cases. So our civil justice reform efforts were aimed at a subset of civil cases broadly defined, but a very important subset, the larger, more complicated cases resolved in our general jurisdiction courts. We were doing other things through other efforts to try to address small claims court or our evictions court. But it's important for people to understand that the focus of this effort was directed at civil cases in the superior courts. We, in setting up the committee, gave it a charge specifically to look at the things that were going on around the country. When I issued the administrative order, I asked the members of the commission to consider the recommendations that Isles had developed, to consider the December 2015 amendments to the Federal Rules of Civil Procedure. Incidentally, when we restyled our Rules of Civil Procedure, and that restyling took effect in early 2017, we embraced the federal rules approach to proportionality as a guide for managing discovery. So that was in the works concurrent with our setting up the Civil Justice Reform Committee. It didn't need to engage in debating whether to take that route or not. That was something we'd already settled on. And then finally, we also directed the committee to consider, as I mentioned, the ongoing work by the Conference of Chief Justices in terms of its civil justice initiative. So with the charge identified, the next big challenge, of course, was figuring out who we ought to include in such a committee. And that, I think, at the end of the day, was critical to our success. I asked Don Bivens to chair it. I had known Don for some 30 years, and I knew that he not only was a tremendously talented litigator, but he had experience litigating in state and federal courts across the country, and I thought that perspective would be very useful. I also knew that he was very effective in terms of bringing people together. He had served as the president of the Arizona State Bar, and he had also served as the chair of the American Bar Association's litigation section. And I knew he had the leadership skills to try to really accomplish what we had set as a pretty ambitious timetable. When we put the committee together at the end of 2015, we knew it would start its work in 2016, but we gave it a deadline of the fall of 2016 to come up with recommendations. So that was pretty ambitious, but I was confident that if anyone could pull it off, Don would be that person. In terms of the commission members themselves, beyond the chair, we actually, Don and I, worked together pretty carefully to give that thought and to try to bring people together from very different perspectives, but also people that we thought could work together in constructive ways. So, of course, a significant number of the commission members were judges. We had about 5 Superior Court judges from around Arizona, but we also had a member of the Court of Appeals who had been a trial judge and who was very interested in issues related to electronic discovery. And we had a member of my own court, Vice Chief Justice Robert Brutnell, served on the commission. We had, I think, 9 or so lawyers who quite deliberately included people who came from different size firms, different practice perspectives, some that were primarily plaintiffs' lawyers, some who were primarily defense lawyers. But we also had representatives from public interest groups, from in-house counsel, and we had a public member who was also a member of Arizona's Judicial Council, the advisory body to the Supreme Court in terms of its administrative responsibilities for the courts overall. So we wanted to make sure that we had different perspectives, but that we had people that would be willing to work hard, and we hoped would be able to accomplish that very ambitious timetable that we had set. I should add that we also benefited significantly, and this was probably another crucial factor in accomplishing the goals. We had great staff support within Arizona's courts. Mark Meltzer and Jennifer Albright were very experienced on working on court reform efforts, and we also had assistance from others, including people at Isles, Brittany Kaufman in particular. So I think that's probably enough by way of background, and it might be a good point to turn to Don, who can talk a bit about how the commission actually conducted its work towards its ultimate recommendations in October of 2016.
Hi, this is Don. I am going to start by spending a little time talking about the process by which we ended up making recommendations to the Supreme Court on what became these new rules, and then into the major areas of change, and we'll drill down into 4 or 5 of those to give you a more granular look, and then hopefully we'll have time for some questions at the end, and I hope you will feel free to submit those questions, because that might be the most interesting part of the program. The Chief Justice has never actually told me how many people he asked to do this before he came to me. But if he says I'm first, I'm gonna take that. But it was both an honor and a significant amount of work. What we had a very diverse group, and there were some very I won't go to heated, but I guess I would go energized discussions about things, because people saw things from different places on the legal spectrum. But what I asked people to do at first was to read everything that the Chief Justice had told us to read, and to come to the first meeting with 3 ideas, and they could either be topics that they thought we needed to discuss. It could be a problem. It could be an area in which they had particular energy. But I wanted to have everybody spend the same amount of time at the initial meeting, voicing sort of why they were there and what they thought their expertise was and what they were interested in. And then we made a list of those, of all those things, and took them one at a time and sort of winnowed down into 4 major areas that seemed to be baskets in which we could put most of the people's concerns or energies. And one was case management. One was discovery issues. One was what to do about compulsory arbitration in Arizona, which is each county can set the limit for it, but basically if it's a smaller case, depending on the county, our rules send you first to a member of the state bar who serves as an arbitrator, and then on to the court if you wished after that. But there were problems with that. There are pluses to that, but it was one of the issues we talked about. And then finally, we talked about just court operations itself. What could we do, looking at the clerk's office, looking at the web, looking at training, to make some recommendations to enhance the future. So we broke down into 4 subgroups, and I tried to place people into the areas in which they had identified the most energy. And our process was to meet monthly as a group of the whole, and then there were intermediate meetings. Then people could set their own schedule by subgroup as to how often they wanted to meet in between. These were public meetings of the whole, so they were conducted with the open meetings law in mind, and occasionally we had other folks come in to provide input or to tell us what we were doing wrong in their view. That process led down to a report that we put together in September, and there's a slide here somewhere, maybe it's the next slide, that shows what we ended up doing, because we did end up with unanimity, and while we had it, I made everybody sign the report so they could remember that they had signed it. And yes, some people who signed it later came back to I won't say criticize, offer different ideas, but at the time we had a unanimous group, and I thought that was a bit of a triumph for Arizona in and of itself, because we did make this unanimous recommendation. We submitted the report to the court in September, and it might make sense for me to turn it back over to you, Mr. Chief Justice. We gave it to you in September, and what happened then?
Well, and what Don mentioned about reflecting on the report itself, the unanimity of support from the commission members relates to the process of what happened then, because the report, I think I may have mentioned earlier, it was ultimately presented first to Arizona's Judicial Council, which comprises more than a couple dozen people, of court leaders, judges, clerks, but also members of the public, members of the bar. And that's the advisory body to the Arizona Supreme Court in its exercising its administrative oversight over all the courts in the state. The council, having received the report, endorsed all of its recommendations. That was the backdrop to Don and staff and other commission members then putting together a petition to the Arizona Supreme Court to make various rule changes consistent with the report's recommendations. We also concurrently were working to adopt some of the other recommendations for training or for a pilot project related to short jury trials that didn't require rule changes. But Arizona's rule process is, particularly compared to the federal system, relatively nimble. Anyone can petition to make a rule change. The petitions that are filed by early January are considered by the court after a notice and comment period. They're considered by the court the following August, and then they take effect the January after that. So we can make substantial rule changes within about a one-year period. And that the commission was unanimous in its recommendations, I think, was very important in the court's rather seamlessly and smoothly adopting almost all of the recommended rule changes that came out of the report.
Well, before we move on to what we did, there's one other footnote on how we did it. I have found that as other states are considering this this type of effort, that they would like to talk to the folks who were involved in Arizona and getting it done. I invite that. If there are folks on the phone in your state who would just like to talk a bit about the process in a more nitty-gritty detail, I'm happy to do that. I had the pleasure of talking to a gentleman who was in my position, but now in Hawaii, who they are in the midst of going through a similar sort of exercise, and I understand that other states are considering it as well. All right, so that's sort of how we did it. Let's move on to what we did. You'll have to forgive us. There's a little bit of time delay when we think we're clicking and when the thing actually shows up. So be a little patient with us there. All right, so the key recommendations, I would have to say, are all share an overarching theme, and that is essentially proportionality. Proportionality was the guiding theme that we saw in the federal rule changes and in the recommendations that the various other resources the Chief Justice gave us emphasized over and over. And using proportionality, we looked at case management, and we came up recommending a tiering system, which I will talk about in more detail in a moment, but essentially trying to triage how many judicial resources and how much economic whammy is it going to take from the parties to resolve this case? Is it small? Is it large? Is it complex? Is it medium? And we'll talk about that in a moment. Another headache that we thought we should tackle was how sometimes in a case, the filing of a discovery motion can just bring everything to a screeching halt because it takes time to both brief the motion, to have the judge hear the motion. And we wanted to see if we could address that. And we did come up with a process which I believe is going to resolve most, maybe 80–90% of the discovery motions. At least that's what it seems to be doing. And we'll talk about that. Electronic discovery was something that we had, if we were going to take a look at what was happening, we felt like we had to address. And I'm not sure that we invented anything there, but we tried to organize electronic discovery rules and processes and nomenclature, and tried to define a bit about what's a burden, what's a good cause, and hopefully we did that helpfully. Cost shifting was sort of the muscle behind proportionality, and the courts have always had, in my view, the inherent ability to tailor discovery orders and case disposition to include an imposition of fees back and forth, depending on how the court saw things. But we wanted to make it more explicit and more of an invitation to the trial judges to please use your discretion in deciding how to proportionately approach discovery disputes, and with an idea that we'll talk about in a minute, that because the rules are a little strengthened, that the appellate courts would back you up. The FastTrack pilot program was our answer to how can we experiment with making the compulsory arbitration system perhaps a little better. And then finally, we had some information about training and making available to the public information about what particular judges' backgrounds were, what they expected in their courtroom, and to make it easier for both lawyers and pro pers to participate in the system. So, with that background, let's take a look at tiering, and we call it, to make it sound fancy, we call it differentiated case management, but it's really sorting things into 3 tiers. And the 3 tiers were just numeral 1, 2, 3. But the first tier, we thought these are simple cases that could be tried in 1 or 2 days. Maybe automobile torts, premises liability, insurance coverage. We gave some examples in here, but something with fairly minimal witness requirements, fairly minimal exhibit requirements. And we wanted to treat them as simple and more flexible and streamlined. And I'll go to that in a minute. A tier 2 case was what we considered something of intermediate complexity, and it's probably what most cases are. They fall into the range of maybe multiple theories of liability, maybe more than minimal documentary evidence, more than a few witnesses, could have some experts, and could involve counterclaims or cross-claims. And those were differentiating factors we thought about for tier 2. And then tier 3 is basically everything else, but what's left, I think, are cases in which there's a substantial amount of economic damages at issue, class actions, antitrust, multi-party, and voluminous discovery, maybe to include a lot of ESI. And we also put the criteria for putting cases into 1, 2, or 3 were not strictly economic, because what I've described so far, I think, are not economic criteria, but we did add an economic component. And basically, there would be a presumption that if your case was worth $50,000 or less, you're probably in tier 1. And $50,000 to $300,000, you're probably in tier 2, and above $300,000, you're probably in tier 3. But we recognized that there were exceptions, and we tried to provide some flexibility. For example, you could have a promissory note for $1 million. Is it over $300,000? Sure. Is it hard? No. I mean, how many witnesses? 1 or 2? How many documents? 1 or 2? I mean, should be a tier 1 case in my view.
So Don, I don't want to get ahead of you, but it occurs to me it might be interesting to the listeners to know a bit more about what are the consequences of being assigned to one tier as opposed to another.
So let me just take tier 1 for a moment. Probably a case of less than $50,000. Probably fairly minimal witnesses and documents. And what we've done there is to limit folks, although when I say limit, you can always come back to the judge and anything I'm saying here and ask for more, to 5 interrogatories, 5 document requests, 5 hours total of fact witness depositions, with the idea that if you need more, you can come back to the judge and ask for it. You could even agree to it, but you better be able to describe why it's proportional and necessary to your case, which would otherwise seem smaller. Tier 3, for example, to go to that one, is we said 20 interrogatories, 10 document requests. I may have that reversed, and then 30 hours of fact witness discovery, and that doesn't intrude into expert witnesses, but it does, I think, capture what most cases can do, and most cases can be done in presumptively. There are time limits with each of those two. The Tier 1 case, we're looking to have it resolved in 120 days by rule, again, presumptively, and be ready for trial. 180 for the Tier 2, 240 days for the Tier 3. Moving things along, but recognizing that not all cases will be ready on the same timeline. I might just add here that we didn't invent the tier. That came out of the Conference of Chief Justices reports, sort of small, medium, and large. And our neighbors to the north, Utah, had been tiering for a year or two before we arrived at that beach. We tried to differentiate ourselves and hopefully improve it by having some non-economic criteria that could go into the tiering. Chief Justice, do you want to add anything on the tiering aspects before we move on?
Yeah, I have a couple thoughts to add. You remarked earlier that sort of a background principle to the Commission's recommendations was proportionality, and I think that's particularly reflected in the tiering. The report, which was very, very well done, noted that, look, discovery isn't the goal of litigation, but I think any practicing lawyer has been, at least in some cases, where discovery is very much the tail that wags the dog, that very quickly the costs of discovery begin to outpace the amount in controversy. And that's unfortunate. To me, that's indicative that there's something wrong with the system. And what we recognized, consistent with Utah's practice, with recommendations of the Conference of Chief Justices, is that there shouldn't be sort of a one-size-fits-all approach to discovery in cases, and these kinds of presumptive guides that result from tiering can help focus discovery in ways that will, again, help achieve the goals of both speedy and inexpensive resolution of cases. And another concern is that with the development of technology and electronic discovery, the costs of discovery begin to even escalate more quickly, and those costs can be often borne by third parties who aren't themselves parties in the litigation, and that's an unfortunate consequence that needs to be addressed as well. So those were all some of the background concerns, I think, that led to the tiering recommendation, but some of the others as well.
As to the mechanics of how does a case find a tier, the logistics for that can be several, but whoever files the complaint has the opportunity to suggest what tier they believe the case is in. Whoever answers has the opportunity to say what tier they believe it's in, and there's a requirement for an early meeting for the parties to discuss what tier the case belongs in, and hopefully there can be a stipulation. If there's not, it goes to the judge, and the judge will place the case into the tier of the judge's making. Finally, I should say that I think one of the impetuses behind the tiering was the notion that comes through in the Council of Chief Justices report, the Isles report, and others, and that is cases move better, justice is better dispensed, and better decisions are made when the trial judges case manage. And yet the sheer caseload in many state courts, including ours, is just not going to permit a detailed case management conference, the likes of which you might see more often in the federal court. So what this was designed to do, intended to do, was to case manage in lieu of, because we don't have the ability for the judge to sort the cases into tiers. So it presumptively sorted, and it was sort of like having a case management conference without having the judge present. So let's move on. I mentioned earlier that one of the bugaboos about our system, and I think probably most, is that you be percolating along in a lawsuit, even where people are working cooperatively, and then suddenly a major discovery dispute pops up, at least somebody thinks it's major, and files a motion to either compel or for protective order, and things grind to a halt because it's not going to move forward. At least parties tend not to move forward when there's a barrier like that. So, and yet we also found that that at the end of the day, many discovery disputes just weren't that hard. It was sort of just call a ball or a strike and we'll all move on. And so we have we adopted, we didn't invent this, but we adopted and crafted a expedited process that drew heavily on what some of the better judges, I think, were already doing in federal and state court. And that is, before anybody files a formal discovery motion, you have to submit it to the court in a short written statement, ideally jointly, and it's a 1.5-page limit. Here's what I think and why I think it and what we want you to do. The other side gets to do the same thing. The parties can request but need not request a telephonic hearing with the judge. And the judge then takes a look at what's been filed, and if there's an ability to either decide the case or decide some of it or winnow it down or better triage it, the judge will do so. To preserve the appellate record as to what went on, there's a requirement that there be a minute order describing what has been done. And if it's one of those disputes that just requires more complex analysis, then you revert back to the standard way of filing a more detailed motion. But we're hopeful that those motions would be reduced in terms of how many are filed. And I think in experience, we're learning that they can be reduced in terms of subject matter covered, because perhaps the informal process resolves 80% of what's going on and there's 20% left over. Anecdotally, I mean, we don't have any hard data on this yet because we just started in July, but anecdotally, just talking to people in my firm, this seems to be working pretty well. It had already worked well before, which is why we adopted it. Chief Justice, do you have any thoughts on this?
Only to remark that, like you, I've heard anecdotally positive reports from lawyers and judges about this aspect of the reforms. And in that regard, I probably should mention the rule changes only took effect July of this year. So the feedback that we have to date is necessarily somewhat anecdotal in nature.
Before we move on, I might just add that one of the results of the new rules is we were trying to embolden the trial courts to case manage and to do so with prospect of cost shifting where appropriate. And we have encouraged the judges and you'll see this in some of our future discussions here this morning, to lean in and ask, well, who wants this and how much is it going to cost? And to think in terms of resolving discovery disputes along the lines of, you can have this information, but I think you should pay for it if you want it, or split it, or some other cost-shifting way. We'll come to that, but I think that's also something that was pregnant in this expedited process, was the power of the judge to say, yes, you can have this, but here are the criteria. All right, let's move on to one of the other areas that we identified early was we have some electronically stored information processes that we added. And here again, I don't believe that we invented anything, but we did try to take what the case law and best practices seem to be nationally and just place it into a rule so that when there are, there's a checklist of things that people ought to go down because it's in the rule, and we require that they actually meet and talk about it on the front end, concerning electronic discovery. For example, there's a requirement that there be a conference up front, and you have to talk about the location and types of systems that are likely to contain ESI. You have to talk about is staging or phasing of the process. Does that make sense in this context? Are there places that are more likely to be fruitful that maybe we should go to first before we go to the place where it might be, but is going to be harder to dig into? The discussion of the search protocols and the algorithms, the keywords that both people think might be used to call out the emails that actually pertain to what we're talking about, as opposed to other things. The sharing and shifting of costs has to be discussed among the parties because it can vary as to how much of a burden it is for people to produce the requested information. And then we're also specifically asked people to sit down and talk up front about how they're going to handle privilege, and whether they're going to insist on a privileged log, whether they're going to look at the Rule 502D in Arizona, which addresses inadvertent production. And I would say, just as a practitioner in Arizona, that I find more people are using the 502D process because it just makes sense. You do your best to call through and to maybe find confidential information, but if you don't, there's a cooperative way to resolve it. We also tried to detail, as you can see on the slide here, what factors actually result in good cause or might be good cause, what factors might result or cause undue burden. And that is, again, listed in the rules. And I'll just give you some of the examples, but people are required to talk about the estimated expense, the anticipated disruption, the efforts that, who has custody and how hard it's going to be to get it, the extent to which request is narrowly tailored, and just the raw amount of money that it's going to cost to go forward on these things. Again, we didn't invent these factors. The good cause is a list of what cases are found to be good cause. Undue burden is a list of what cases are found to be undue burden, but it is all collected in the rule, and there's a requirement that people talk about them and address them. So that I might add that 40 days after our initial disclosure statements, which we're not going to talk on here because they're already part of the fabric of Arizona, is when people are required in the first instance to exchange their ESI. So we're trying to front load that process so that relatively soon in the case, we see what everybody has. Mr. Chief Justice, do you want to add anything to that?
No, the only thing I would add I see is on the next slide. So I think if we turn to that, we'll be in the right place.
Okay. Was this your topic?
Yeah, I was going to mention that there is a new process that allows people that receive preservation demands, and again, this is something that I think is part of the daily work of most lawyers these days. Their clients get demands to preserve various kinds of information, particularly electronic information, and under the new rules, there's a mechanism for the recipient of those kind of demands, if there's an issue about whether they're unduly broad or burdensome, to get early court resolution, and that then would insulate them from later being second-guessed and accused of not properly preserving documents and the consequences that can go with that. And I think this is something of a new addition under Arizona's rules.
Yeah, this one I think we can claim to be novel. And this process that the Chief Justice described of going in and getting a court order, if necessary, to tell parties what should be preserved and what cannot, has a safe harbor, and it's in 45.2G, and because it's short, I'll read it. It says, a party or non-party who complies with the preservation order obtained under this rule is deemed to have taken steps to preserve electronically stored information under Rule 37G. So it means you're home free if you complied with what the judge told you to comply with. And interestingly, I think we should stress it can be a party or a non-party, and it doesn't have to be, and often there isn't, a pending litigation. We've created a process at the clerk's office where people can come in and ask for this type of preservation order without the lawsuit pending. And maybe there's never a lawsuit, maybe it follows later. Of course, if there is a lawsuit, then the presiding trial judge should take the lead on that. The next topic that probably bears some discussion is very related, and it is some changes to Rule 45, which is the subpoenas directed to non-parties. And what we've tried to do here was to recognize that subpoenas can be burdensome on the third party, particularly if you're a third party that holds certain key records socially. And maybe you get bombarded with Rule 45 requests on a daily basis. So we made it that you can't get the materials from a third party if they've already been produced or available from somebody else. You've got to show that this is going to be fruitful. We're not just causing expense. And there's an explicit requirement or opportunity to require that the person who is serving the subpoena pay reasonable expenses to the person who's responding. And this can include, need not, but it's up to the judge, the cost of the business disruption. It could be the cost of hiring a vendor to do it. It could be the cost of dedicating employees to do it over so many hours or days. And this was meant to address, well, we had some significant input from the community to address what people who received these subpoenas thought, from their perspective, they were being harassed, that they are being bothered. They know they have a duty to comply, but they weren't sure they were supposed to fund it from their own pocket. And this gives the people who are serving the subpoena some responsibility for the consequences of what they're asking for. We've also relaxed privilege law requirements in this context. You can certainly get one if you think it's important, but by and large, the rule requires if you request it that you need to help pay for it, because it can be a time-consuming process to cull through. There is a duty to confer in these Rule 45 issues, just like there's a duty to confer now peppered throughout all of our civil rules. So hopefully this can bring some relief to at least that portion of the community that felt like they were being burdened by fights that were not their fights, but they ended up paying for somebody else's fight. Mr. Chief Justice, anything there?
No, but I'm thinking that given the time that we have remaining, it might be good to talk only briefly about Rule 37, so you can talk a little bit about the pilot project involving short jury trials.
Well, in fact, although Rule 37 is next, we sort of discussed it already. We tried to beef up the trial court's ability and the litigants' receptivity and expectation that cost shifting could make a difference in all these issues that we've talked about. But I don't think I have anything else to add there, unless we come back and we have a little bit of time. It might be worthwhile to drop a footnote here, though, about the training that we have talked about that became necessary as we begin to realize that these are rules that are new, both to the judges and to the litigants. So before we move on to that pilot program, let's talk just briefly about what we did so other people in other states could appreciate the training aspect.
Yeah, and as was true when those LACIT rules were adopted back in the early 1990s, it's one thing to change the rules, but to actually have an effect, they need to be embraced by the judges and by the lawyers. So we actually were very deliberate in terms of alerting people to the prospect of the rule changes and then trying to basically get them ready to, when the rules took effect this past summer, to actually begin using them and having them guide the course of litigation. So some examples: we had presentations in October of 2016 and again in October of 2017 at our annual Court Leadership Conference, which brings together judges and court administrators and other court leaders from around the state. In December of 2017, before the rules were going to take effect, Don published a very good summary in the Arizona Attorney about the key features of the rules. We also did a bench bar seminar in Tucson that month that had hundreds of attendees. And over the past year, both the courts through our Education Services Division and the Arizona State Bar and the County Bar Associations have offered numerous education programs. And I think that too, as for reasons I've said, in terms of actually effectively implementing the changes, those kinds of efforts are critical.
Let's move on to talk about changes to the compulsory arbitration system in Arizona. Again, every county has their own ability to set the financial threshold for these cases. I'm going to use Maricopa County as the guinea pig here because it's a $50,000 limit, and it's the one that I am most familiar with. So small cases, say a $35,000 case, before this new rule, you had to go first to a member of the state bar who may or may not be a litigator, may or may not be interested in being the arbitrator, but is literally assigned to the litigants. And because it was everybody exercising good faith, still had, I think, the prospect for some arbitrators are better than others. some move faster than others, and it wasn't a uniform approach. And it was still costly. It still takes time. And we worried about, hey, doesn't the right to trial come in here somewhere? Do you lose your right to trial because you have a $10,000 dispute? That was sort of vexing and percolating around the edges of our discussion. And there was also, I think, a recognition that with compulsory arbitration, we had been raising a generation of lawyers who had less and less trial experience because they simply didn't go to trial on small cases. And some people thought that was actually not a bad thing, and other people thought it was losing the profession that we once had. But it was a thought behind trying to give people, what you'll see in a minute, was the opportunity for a short trial. And that there was enough controversy surrounding this that we decided that we could not make a recommendation for a general rule, but we did look for a place to do a pilot program. And fortunately for us, the lawyers and judges in Pima County were willing to do that. I'm going to just show you describe the brief model for that. And we're having trouble, Brittany, with our slide. If you could get to the next one, that'd be great. But in short, this is a Dr. Seuss level illustration here. But what happens now under the rules in Pima County is that the plaintiff gets to choose whether to go to arbitration or for a fast-track trial. If you choose arbitration, which you'll get back into the system I just described, but you would waive your right to appeal that arbitration to the Superior Court. If you take the fast-track trial, which I'll describe in a minute, you would have all the appellate rights that come with somebody who goes to trial. But the fast-track trial is designed to go to trial in 6 months, no more than 2 days, very limited discovery, not supposed to be costly. And we didn't know when we started this how many people would opt for one or the other, and we still don't know in any statistical way, but anecdotally, it seems to be that about half of the people choose arbitration and about half the people exercise the option for this fast-track trial. And we were hoping that that if they have the choice, the litigants would tend to be more both accountable for and satisfied with the route that they chose, because you're not having a a process inflicted upon you, you have made a choice as to which process you prefer. And if you felt like your right to trial was being snubbed, you have a right to trial, and you can go that way. This proved to be one of the more thorny regulatory and rule writing things that we had to do, and it dragged a little behind some of our other rule implementations. But so far, at least from my perspective, the reports are mostly good. Mr. Chief Justice, you want to talk about that?
No, I don't really have anything to add to what you said. I am pleased that the reports so far are good, and we're looking forward to seeing what we can learn from this pilot project.
Okay, let's get on to the last topic on our list here before we will open up for questions. And this was came out of one of the 4 groups that we formed that focused more on operational issues. And there were, of course, a number of changes that had to be made at the clerk's office and in the rules to make all this happen. But we also tried to look at what the practice was right now on court websites and in terms of judicial training for both informing judges how to be better judicial officers in the context of a civil case, and to inform litigants about what to expect when they got in front of a judge who was handling their case. So at one level, we looked at the website and we found that it's not uniform. We had some judges who had very good information, very, very detailed information about, in my court, I would prefer this. In my court, I would prefer that. If you please submit an order in Word format so I can change it. Yet there were other judges where there's just a blank. And it seemed that if we could encourage some uniformity of what the public could find out from the judges, it would be good. So we have moved toward creating a uniform template that for all the Superior Court judges everywhere in Arizona, that you ought to be able to find out the same types of information that could be useful. The other thing we noticed, and this was not ubiquitous across the state because some of the smaller counties don't have this rotational system, but in the larger counties, Maricopa in particular, the judges rotate traditionally through a series of the different divisions that the Chief Justice talked about earlier: family court, criminal court, juvenile, and typically civil comes later down the road, and it comes years after the training that people had on the front end for how to handle civil cases. So recognizing that, we made a recommendation that in that 60-day period before the rotation takes place, that there be some deliberate refreshing as to you're moving into civil now. Let's refresh on the things that you're going to be responsible for there, and have the judges who are handling the civil dockets already share the experience and the knowledge that they already have. Mr. Chief Justice, anything you want to add there? You probably know a little bit more about the systems here at the Supreme Court than I do.
Well, I'll just say those efforts are underway, and a challenge we face, and I'm sure in many other states there would be a similar issue, is that our superior courts are organized by county, and there are, for instance, distinct websites for the superior court of each county. And that means that in terms of adopting some uniform practices, it takes us a while to get there, but that's an effort that's underway.
We have just another minute or two before we had planned to open the questions. So let me talk about an odds and ends topic that was smaller than some of the broader areas we've discussed, but people ought to know about. All of us has probably experienced, and if we're honest, have probably done an answer to a complaint that contains something like the document speaks for itself, or deny any allegations inconsistent with the document, things like that, or it states a legal conclusion. We basically talked all this over and thought that those practices are not helpful. You ought to be able to state whether you agree that the document provides for such and such. For example, in a request for admission, admit that the payment terms are governed by paragraph A of the contract. Well, something that says a document speaks for itself doesn't answer the question. A better answer is yes, paragraph A controls, or no, paragraph A does not control because 30 days later the parties agreed to this modification here on Exhibit 4. But at least that way you can come to grips with what the real issues are and no more evasion. And the same goes for an allegation by claiming that something is a legal conclusion. Do you agree with the legal conclusion or not? If you dispute that this is the applicable law, just say so, and we'll move along. So we don't have to wonder about which law applies or how you think the statute should be interpreted. Again, Mr. Chief Justice, anything to add there?
Well, I think this is a good example of the more general perspective that discovery isn't the end of litigation, and what we should be doing is focusing on how do you most efficiently exchange the information that's going to lead to the just, speedy, and inexpensive resolution of the case. And one thing I think, and this partly reflects my own experience in private practice before I joined the court some 13 years ago, but I think most lawyers recognize and would very much endorse the idea that we ought to, cut through the wheel spinning. We ought to reduce the unnecessary fights about discovery or discovery about discovery. And that's the spirit that animates these reforms. In some ways, it's going to be a major change to how we've approached things in our civil cases in Arizona. But the same was true about the Zlacket rules. And I think with time, people are going to come to embrace these with the same enthusiasm.
Well, that summarizes what we had hoped to talk about in terms of how we did the civil justice reforms and what we did, at least the major themes. If people are interested and we have time, we can talk about some proposals that hit the cutting room floor. We can talk about some proposals we think may be yet to come. So we finally reached the point where it makes sense to open things up for questions, and we'll do our best to field them.
All right, great. Thank you both. We have had a couple of questions come in, so I'm going to throw those out for you. The first one is a reference to the Conference of Chief Justices report and its #1 recommendation, which talks about the court taking ownership of cases and recognizing the court's responsibility for those cases from filing to disposition. So the question states that the Conference of Chief Justices call to action report makes the central point that increased efficiency and effectiveness in distribution of justice is best achieved by shifting case management responsibilities from the parties and litigants and their legal counsel to the court. So recognizing that, what is the best process for effecting this shift in case management to the court?
Well, I think the rule changes certainly contemplate more active involvement by the judges, and that's consistent with some changes Arizona had made earlier. A point, though, that Don alluded to that I think is an important one is you want active engagement by the court when it's necessary and it's going to be most effective. So, you don't want judges micromanaging every case from the filing of the initial complaint. You want the parties to be guided by things like the tiering to efficiently engage in discovery and the raising of motions and bring the judges in where they're going to be most effective in moving the cases along.
Let me chime in. I think if the question asks what's the best process, I think the best process is something beyond the powers of even the Chief Justice, because it would be to fund the system to a point where caseloads are such that individual judges could spend individualized time trying to help the parties come up with a special scheduling order and case management process tailored just to their case. We see that in Arizona a little more closely in the federal cases, in the federal system, but we recognize when you're talking about state court, the sheer number of cases that are assigned to each judge and the resources that Superior Court judges have, which pale really in comparison to the federals, just is not going to allow it. So we phrased it as, we know we couldn't get the best process, but what could we do to get the most reasonable process out of our existing system without spending money. And that to us seemed like the tiering was a good start. And I think that's actually what the Conference of Chief Justices ends up doing too. I mean, they're recognizing that case management works. I will say I've done some of these programs around the country, and the feedback I've gotten from some of the judges is that a lot of judges would be willing to case manage if they knew how. And they just, the culture in some cases, in some states, is more like this is the lawyer's case, I stay out of it. But we're hoping with rules like this that encourage thoughtful cost shifting, that encourage thoughtful proportionality as to what does this case, what's at stake in this case, and then how do we keep the attorney's fees consistent with what's at stake. That should empower the judges to step up a bit. I think that's what our hope is.
Wonderful. All right. Another question harkens back to your discussion of requests for the preservation of electronic information. The question is, do you think the safe harbor provision will apply if the case is eventually filed in federal court?
You know, that's a very interesting question. You found a nook and cranny that I can say I've never thought about. I would say that most federal judges find it somewhat interesting when over what happened in state court, but I don't think they find it binding on their lifetime appointment and their discretion. So my guess is that I'd certainly raise it if I was on the end of a spoliation order, and I would hope that the judge would take that into consideration, but it certainly isn't binding, in my view. Mr. Chief Justice, what's your thought?
Well, I share your concluding observation. I think it would certainly be powerful evidence that a party had acted in good faith and reasonably, but I don't think as a legal matter, I'd be a little surprised if a federal court thought that once the case was in federal court, that was determinative in a legal sense.
But that's a good question. Very good question. And as we go along, we're finding that the law of unintended consequences applies to these rules as well. And hopefully, as these things arise, if there's ways to address issues like that, we can find ways to address them.
All right. One last question I'm going to throw out. One of the attendees is wondering if you all did a landscape as recommended by the National Center for State Courts and the recommendations in the Conference of Chief Justices, and did you pull data from Arizona, and how did that inform, or did it inform your determination of the tier amounts of the 50,000 and 300,000?
Well, I guess the answer is we did the landscape consistent with the funds and resources with which we had to paint the landscape. And I would say that the Conference of Chief Justices report in the IELTS report that we have referenced in many ways are our landscape because they provide a lot of data-driven information about things. We do mention in the report that there are surveys that we relied on to encourage us to go further in the direction of cooperative disclosure. At least in Arizona, as far as we can tell, most lawyers who practice both in federal and state court prefer state court. And one of the reasons they prefer state court is because of the disclosure environment. A lot of these proposals that we have turned into rules are really disclosure, maybe on steroids, trying to get people to talk and address certain specific topics early in the case, to not waste money, just tell each other what the fight's about and bring it to the judge. And that's about as smart as I feel on that issue.
Well, and one point that raises that again is worth mentioning is our focus in our Civil Justice Reform Commission was on civil cases in our superior courts, And that was a narrower focus than the Conference of Chief Justices had with respect to its Civil Justice Initiative. Their landscape report looked at civil cases more broadly defined. So one point that they made as a result of their landscape report was there are a lot of small dollar cases, for instance, small debt collection cases below, say, $15,000. Those would not have been the focus of our Civil Justice Reform Commission because in Arizona, those would fall within the jurisdiction of our limited jurisdiction courts. And we have other efforts aimed at improving small claims case processing in those courts. So we didn't undertake that kind of survey in Arizona, as did the Conference of Chief Justices. We have case information statewide on kinds of cases, and so we didn't really need to redo that kind of survey from just from the start.
All right, wonderful. Thank you so much. That's a nice segue here into the last two slides I have just to share with everybody in terms of what's happening nationally, and that reference to the landscape, I think, is again a nice segue. I'm highlighting here a roadmap for implementation, and coming out of the Conference of Chief Justices report, ILES and the National Center for State Courts have teamed up on a 3-year project. We're actually just starting into our 3rd year on this to support implementation of the recommendations around the country and to hopefully inspire and support other states like Arizona to take up the call to action and look at their own dockets and their own challenges and come up with their own set of recommendations for their own state courts. And so we have been working with states around the country, including Hawaii is now, as was already mentioned, taking up this charge, Idaho, Oregon, Missouri, Texas, Maine, and many others, which is very exciting to see so many states around the country setting up similar committees and task forces to take a look at the recommendations. And one of the things that we did with NCSC is to come out with a roadmap for this and just make a clear set of steps for states to follow. And as was referenced, there is the second step, which is to look at each state's own docket. And I know there was the reference to kind of the capacity for doing that landscape. One thing I would recommend for those who are on the phone and thinking about these issues is to look at that NCSC landscape, because what we have found is there are states that either don't have the capacity to do a landscape, or they don't have a lot of information because they haven't been gathering it or have not had a lot of case management information in their own state courts. So where those challenges exist, I recommend looking at the national data because it's been pretty informative. And so from there, I also wanted to recommend that there are other tools and information for state courts to look at. So as you all are looking at reform around the country, I encourage you to take a look at the National Center for State Courts website, which I have here. It includes all the tools that we have developed to support courts around the country, as well as our own website. We have a map that maps out everything that's happening around the country and provides information. For example, if you go to Arizona, you'll find a link to their order and the initial charge, the order, the state, your own report that you shared with us, and all of that information. So we try to link to all of what's happening around the country so that we are a great resource for folks. And so with that, I just want to thank everybody for attending. Thank you so much, Chief Justice Bales and Don Bivens, for sharing your experiences, your successes, all the lessons you've learned. I think that you have, as a state and personally, been very inspirational to everybody around the country. So I appreciate you being part of this program here today. And also thank you to our Business Leadership Network and our Law Firm Council. In terms of CLE, we will be following up with all attendees with CLE information and forms, as well as some wonderful materials that our presenters have gathered for you all today. and also a copy of these slides. So thank you all for attending. I encourage you to check out ISLE's website and look forward to having a program again for all of you in the future. Thank you so much.
I'll be your sidekick anytime. Always fun. Thank you.